three-pronged, which is very helpful. Oh, but before there's a preface, really, or a preamble that I would have to do, because during the break I saw some of our viewers saying that, please help elaborate on the issue of clearly wrong and wrong clearly. Clearly wrong is like saying Kenya is in USA.
Yes, that's clearly wrong.
Yeah, at least for most Africans, they would say you are so clearly wrong. There's no debate. It's a no-brainer, as Americans would say. You just need a skull to know that Kenya is not in America or Kenya is in Africa. So that's clearly wrong. Wrong clearly is there where you are, especially in argumentation. In argumentation, it's normally not on things which are obvious like day and light. It's many times in areas which are gray, which require you to have some background information, background evidence or background understanding of the law. So one can be wrong clearly because they are convoluting facts with or evidence and the law. They are both interpreting the law and applying the facts, and this listener may not have either or both. You get? You may not have the evidence.
Ben, you're drawing very fine distinction.
Or you may not have very... so, for example, when somebody... they are wrong. In other words, they are wrong, but the way they are eloquent... and
you can't catch the wrong.
It's not very easy to catch that. Like if somebody just says out there that, like one said, one IBC lawyer said, do you know what? We don't take into account turnout on the issue of presidential election. You know, unless you have read the Constitution and known that turnout is equal to votes cast, turnout is about votes cast, really. Then you have to have that background information for you to know that that is really clearly wrong. So they can be wrong, but the way they articulate, the articulation is so clear that you are swayed. And most of the people, lawyers use this. Let me tell you one thing.
This is what you train them to do.
Lawyers, lawyers use this. Lawyers use legal argumentation, which is many times, and the facts and the law evidence may be very clear. Then lawyers use what is called rhetoric. And in every case will have a rhetoric, and every lawyer will apply some rhetoric. Like this phrase, the law is very clear, is rhetoric. And that lastly, related to rhetoric, is what I call emotional blackmail. In other words, you are being told, no, excuse me, audience, the law is so clear, and this is the fact. And it was decided when they are even lying, and when they emphasize those emotional and even quoting Shakespeare and stuff like that, they want to impress you and bring you back and say, do you know what? There is no case here. This is sound and fury. No much ado about nothing. And you get swayed. Oh, it must be much ado about nothing. It must be de minimis, nothing, minimal. No, but what is the evidence? What is the law? What is the fact that and many times these are techniques that are used to persuade. Sometimes they succeed with some judges, but judges who are circumspect will ask you those difficult questions that were being asked. They say, no, we can hear you. We can hear you are referring to Solomon, King Solomon. We can hear you are doing this. But please, can you also, what is the law and what is the evidence? And Cicero was very good in this. One of the celebrated rhetoricians. And by rhetoric was taught in classical, serious classical universities at doctorate, PhD level. I've seen professor of rhetoric. Rhetoric, just to persuade. And some lawyers have nothing else but rhetoric. And that's not very good. Rhetoric is important, but must be rhetoric based on substance, text, structure, and history. Let's go to the issues that were on the table.
You're employing the tactics now.
The rhetoric is based on substance. There must be, even if there is, if you say there is, and I don't deny, it must be based on substance.
Okay, let's go to the substance.
I think you are, this is also part of substance. I think there's been this debate about the Supreme Court and the BBI issue. Just one statement. Please, the Supreme Court, in a clear decision, found that substantially found for BBI. So I don't really want to debate that further. I think we've debated this quite a lot and we can debate it again. But just to say that BBI was intended to and made a very major contribution to this debate, especially on this key issue that relates to presidential election petitions. The question of shared prosperity, the question of winner takes it all. We know from our history that we tried at independence with a parliamentary system of government. British model, Westminster export model. It failed. We tried from 2008 to 2013, we had the Grand Coalition government, which was now what I would call hybrid or semi-presidential system, or the better name is parliamentary leaning executive, where the executive was in the House. And it worked well. It gave us the 2010 Constitution, which is celebrated. It gave us the Vision 2030 policy framework. It gave us happiness and reasonable in the agreement in Kenya, which I think the handshake also gave us, that we ought to be able to work together as Kenyans. Lastly, is that even in the US and the UK, and this is a major contribution by BBI really, even in the US and UK, they are saying that we cannot sustain these pure systems. The British are saying we can't sustain this pure parliamentary system. You are going to have a Boris, this immediate former PS, former PM, yeah? Boris Johnson, coming with a lot of rhetoric and getting you out of EU before you know it. There's so many problems, etc., etc. Nor can we have Americans. Nor can we have a pure presidential system, because we may have another Trump, another Nixon, etc., etc. And therefore, and the way we do this business, we really need to review this. And this debate is going on. And BBI, therefore, was a very serious, made a serious contribution on this.